of Melick Law, not WBEV or Good Karma Brands.
Good morning. It is 11:10 at 95.3 WBEV and Daily Dodge TV, and it's our time for our monthly chat with Rob Melick from Melick Law. And if you want to watch us, you can do so at Daily Dodge TV. Just search that on YouTube, and make sure you hit the like, subscribe, and notify button. And every time we talk, you will get a notification, and you can see our smiling faces here on a Monday. Rob, how are you doing today?
I'm doing well. How are you, sir?
Hey, thank you so much for joining us here today. And what's going on in your world?
Not much. Just from a family perspective, this is the last weekend of football. Well, actually, my younger son has a playoff game this upcoming Saturday, and then that'll be the last weekend. And transitioning right into hockey, something I know is near and dear to your heart as well.
Exactly. So can you ask where your son goes to school?
Yeah, my two boys go to University School in Milwaukee, private secular school in Milwaukee. So I have a freshman and a sixth grader.
All right. And so who does your school have in their first round?
Actually,
the sixth graders playing?
Yeah, the sixth graders playing. So he doesn't play for USM.
Okay,
Actually, we don't even know yet who they play because it's based on what the eighth graders do. But they beat Cedarburg last weekend, so they'll play whomever the eighth grade team is playing, and that'll be kind of their end of the season thing. So it's been a good year for them.
Exciting times, as you mentioned. Transition to hockey. My daughter finished up high school volleyball for the JV squad over at Beaver Dam High School, and 6 a.m. this morning they had hockey practice.
That's the life of a hockey parent, just the way it goes.
They're dropping off that bag. And now I have one hockey question before we talk about Melick Law.
Sure.
Are your children who play hockey, do they have the roller bags, or do they have the bags they carry on their shoulder?
No, we stopped allowing roller bags once they hit squirts. So,
okay, is that what it is?
That's our family rule. It's you can be a man and carry your own bag at that point.
Exactly.
So that's kind of our thought there.
It's always the question that you have, because some kids have the rollers, and some my daughter's transitioned out of it as well.
For sure.
And it's easier to roll, but carrying is just thing to do, getting upstairs and such.
It is, and it's one of those things where it's the expectation. You carry your own hockey bag, so kind of the standard we've set in our house. And the same thing with skate tying. We stopped that in Pee Wee's. So
with skate time.
Tying the skates.
Yeah.
Kids can tie their own skates at that point in time. So if they can't, there's issues. So
exactly.
We try to preach that autonomy and that independence. And I have a rule that if for first year Pee Wee's, I'll tie their skates for play downs and state tournaments if it's an important game or whatever. Championship game of tournaments. But beyond that, they tie their own skates.
Once you figure it out, it's okay, right?
Well, that's the thing. And the other thing, too, is we encourage the kids to at least try it. No matter how good or poor of an effort they give, at least they're trying it and learning how to do it, because at a certain point in time, it's embarrassing when mom or dad comes in the locker room to tie your skates. So we don't want our kids to have that experience, so we kind of teach them trial by fire there.
No, and there are many opportunities to play hockey, in your neck of the woods and right here in Beaver Dam, and plenty of opportunities. If kids want to get involved in that, it's I'll put my 2 thumbs up and my stamp of approval. You will too, right?
Absolutely. Hockey's a great game. I mean, it's one of those things where I grew up. I was always a football player playing hockey. That was kind of the thing. Hockey was the off-season sport. I was built for football. My boys are the same way. Genetics are a powerful thing. But at any rate, they enjoy it. It's a fun time. It's just a long season. I mean, we had tryouts mid-September for Winter Club, and the state tournament extends all the way to first week and second week of March. So it's a long marathon. But the boys each have their first games this weekend, so we'll see how they go.
Nothing more exciting than getting that first game and getting on the ice for the first time.
You bet.
Hey, Rob, Melick Law, I guess before we get going and talking about things going on today, tell us about what you have to offer and everything you do.
Yeah, so Melick Law, I've had my own law firm for 8 years. I had an 8-year anniversary September 1st of this year. Our firm focuses exclusively on estate planning, trusts, wills, powers of attorney, probate, things like that. What I found in my experience is these are the types of areas that people know they should look at. They know they should have an estate plan in place, but for whatever reason, passage of time, people being busy, not understanding what an estate plan can do, people tend to put it off. And what I do through shows like this is try to educate people as to why they may want to reconsider that position and not put it off, and create these plans so that they have a peace of mind for as long as possible. And that really is the biggest issue in my practice. Again, I'm a first-generation lawyer. A lot of these things you just kind of learn while you're in practice. They can't really teach you that in law school. And what I've learned is that the majority of the reason people put off estate planning has nothing to do with cost or time or anything like that. It's simply a lack of information. I have found to be a huge gap between what people think an estate planning can do for them and what in actuality an estate planning can do for them. So it's through shows like this, through free initial consultations, through seminars that I provide where I try to bridge that gap a little bit, because what I found in my experience is once people know what an estate plan can do for them and not just what they think an estate plan can do for them, they're much more inclined to take the steps to create an estate plan immediately.
Well, if somebody wants to get in contact with you at your office and maybe begin the process, how do they get in contact with you and tell people where your offices are located?
Yeah, you bet. So best way to get a hold of me is always by phone. I may be millennial, but I'm old school in that regard. I'm a fan of just picking up the phone. I do have email and text options as well, but my number is for all my offices is 262-347-3444. Again, 262-347-3444. I do have 4 office locations for the majority of the listening and viewing audience. My office in Beaver Dam is probably the most proximate. The folks over at Higher Insurance are generous. They let me use their office to meet with clients. I actually meet with a couple clients right after this show. So for most people, that'll be the closest location. But if you're up for a drive or if you're listening from a further away area, I do also have offices in Richfield, West Bend, and Port Washington. Now, my Port Washington office will be converting to a Saukville office probably by Thanksgiving. I bought an office building in June in Saukville, and renovations are undergoing right now as we speak. So hopefully plan to open that office in or around Thanksgiving, closing out the Port office and then moving to Saukville.
All right, I actually was in Port Washington Friday night for a high school football game, and
Sure.
I had actually never driven through Saukville. I had been to Port Washington a few times before, always come like on 43, and I had never been past West Bend Lakes Golf Course
Sure.
on 33 until a couple weeks back. I was in Newburgh and Saukville for a cross-country meet, and then last week we were there, and beautiful, beautiful area over there.
It is. I actually used to live in Saukville from 2016 to 2020. I lived in Saukville, my family and I. So when I saw this building up for sale in Saukville, and by my unofficial records, I believe I'm the only practicing attorney in Saukville once I opened my office there. Not just estate planning attorney of any kind for a town of 5,000 people. We actually bought the old post office in Saukville. It was a post office before. It was an insurance company, and then I bought it from the gentleman who was running as an insurance company. So we're excited about it. It'll be nice to have our own office. It's divided offices, about 2,000 square feet, give or take. So nice conference room. I actually just purchased the TV for the conference room today. Costco will be delivering it later this week. So, yeah, very excited about that.
Well, if anybody's got a question on the air, they can give us a call at 920-886-95. Oh, I've only given my number how many thousand times on the air here today, Rob, and I just gave it wrong.
It happens.
885-4446 is the on-air number. I almost gave the text line.
I was going to say, whatever works, just make sure we get the number right. It's how many effort it takes there.
920-885-4446. You mentioned people say wills, trusts, estate planning. Maybe they kind of think they're all tied together, but they're all kind of different, aren't they?
They are, and depending on where you're at in your stage of life, one type of plan might be better than the other. Mm-hmm. One might do more for you than the other. But I start with a basic premise, and this is a premise that surprises a lot of people. But I've said it many times in the show. Every single person over the age of 18 needs to have an estate plan. Mm-hmm. That surprises people. That people think, why in the world would an 18-year-old need an estate plan? And it may not be for the reasons that you think, because let's face it, most 18-year-olds don't live on their own. Most 18-year-olds are not independently wealthy. Mm-hmm. Why does Rob take the position that every single 18-year-old should have an estate plan? Because an estate plan is not only dealing with wealth. It's not only dealing with the transition of assets upon death. It also deals with the word that we don't want to think about, but happens every single day, and that's incapacity. I always take the very logical base position that every single one of us, regardless of age, regardless of health, we're all one moment away from incapacity. Bad moment behind a wheel, sudden onset of a disease, every single one of us can go from being perfectly lucid, perfectly capacitated in time 1 to completely and permanently incapacitated in time 2. And the fortunate thing is that does not happen to a large percentage of people. In other words, the overwhelming majority of 18-year-olds will not be in a position where they lose capacity. The problem, of course, is that percentage is not zero. Yeah. It's somewhere north of zero. I'm not a statistician, but I know it's not zero. It's somewhere north of zero. So because of that, planning is a good idea. So let's talk a little bit more about the average 18-year-old in the state of Wisconsin, okay? I'm going to state some very basic facts here that I really don't think are in dispute. The average 18-year-old in the state of Wisconsin is a senior in high school.
Okay.
Now, granted, there are some people who graduate high school early purely because of my birth date. I have a July birthday. birthday. I graduated high school at 17, turned 18 immediately after. But the overwhelming majority of 18-year-olds reach their 18th birthday while still a senior in high school. I think that's pretty indisputable. Even though I don't have hard statistics to back that up, It's more anecdotal, right? I think also, similarly, most 18-year-olds still live at home with their parents. Most seniors in high school still live at home with their parents. Now, certainly, there are some 18-year-olds who are emancipated adults. I have a couple 18-year-olds who are married, live with their spouse, some 18-year-olds in the military serving our country, but that is the overwhelming minority of 18-year-olds. The overwhelming majority of them are still living at home. So given those two facts, that the average 18-year-old is still a senior in high school and the average senior in high school still lives at home, if I polled 100 random people at Walmart and I asked them, if you have an 18-year-old senior in high school who's still living in your home and that 18-year-old is in a horrific accident that renders them incapacitated, do you think their parents have the ability to make medical decisions and receive information regarding their care? In my experience, about 95% of them would say, of course.
Yeah, they live at home. They're under my roof, right?
With their parents, they're still seniors in high school. But I will tell you this, as a matter of law, the moment an 18-year-old reaches the age of 18, they are now subject to HIPAA protections. And I'm sure most people in the listening audience have heard of the term HIPAA before. HIPAA, to give a little background, is a federal statute that stands for the Health Insurance Portability and Accountability Act. Basically, it determines when and under what circumstances medical professionals can share your medical information. Now, as a general rule, we don't want our medical information shared. We want to be able to have doctors preserve the confidentiality of that information. The problem is we can't pick and choose the applicability of HIPAA. So, for instance, when that 18-year-old presents at the hospital in a coma, we can't assume that that 18-year-old would want his or her parents to know that information. So the only way to guarantee that medical providers will share that information with you as a parent is if that 18-year-old has a very basic estate plan known as powers of attorney. Healthcare power of attorney, the ability to nominate someone who can make medical decisions in the event that somebody is alive but incapacitated. Because the problem is, in that example I gave where that person's in a coma, that person, that 18-year-old, cannot agree to have mom and dad receive that information. So it can't be assumed by the medical providers. So as a parent, that's a scary situation. Now, to be clear about two things. One, and we're in this situation, we have children under the age of 18, okay? Up until 18, no problems. Parents can receive that information, can make those medical decisions, no problem. The day they turn 18, we lose that without a power of attorney. So that's assumption number one. Assumption number two is this. Again, fortunately, not all medical issues require or necessitate somebody losing capacity. So, for example, if my 18-year-old child is involved in that same car accident, instead of ending up in a coma, breaks his leg, certainly he can say at the hospital, hey, I have a broken leg. Please call my mom, please call my dad, and let them know I'm here. That's one thing. They are lucid. They have capacity to be able to explain that. But if they don't have capacity, as in they're in a coma or they're unconscious for some reason, then we cannot give that information. We cannot receive that information as parents.
So what happens, okay, say if you get the situation you said, which would be the worst case scenario, you have an 18-year-old and you don't have an estate plan. Mm-hmm. Legally, so under the legal guidance of it, they can't. What would a doctor do? Would it be up to the doctors and the medical staff to make decisions as opposed to a parent who probably is the person that would want it to be done? But legally, is it one of the cases where a doctor legally cannot have somebody else do it because then it could come back on them if a decision is made?
That's exactly right. The hospitals make those decisions. They have ethics boards who make decisions. Because let's face it, forget the 18-year-old for a second, right? I'd be willing to bet if you went to any hospital in the state of Wisconsin and you went through every single person in the ICU there, of course the rate of having powers of attorney is not 100%. Mm-hmm. It's probably significantly south of that 100%. So again, most people in the ICU would be over the age of 18, so it would apply just as much to an 18-year-old as it would a 35-year-old who didn't have these documents in place. The only other remedy is a court-ordered guardianship, and that's a process that could take a very long time and be significantly more expensive than creating an entire estate plan because, again, at that point, you'll need medical testimony. You'll need a guardian ad litem, who's usually a lawyer who can explain, yeah, I've met with this person. They don't have capacity before a court ultimately renders a judgment. In these cases, through no fault of the court's own system, are always pushed to the back of the line. Why? Because we have this wonderful thing under the United States Constitution known as habeas corpus. That's a phrase some people are aware of. Basically, it guarantees the right to a speedy trial. And in a criminal sense, that's a wonderful thing, right? Mm-hmm. When you talk about criminal defendants, it's the potential loss of liberty. So those get pushed to the front of the line, so to speak. When it comes to civil matters, which are non-criminal matters, those typically get pushed to the back of the docket because, again, criminal defendants have a constitutional right to a speedy trial. So if there's 10 cases on the docket, the criminal ones always get the emphasis and the other ones get pushed to the back of the line implicitly. So again, this can all be solved very easily, very inexpensively by creating basic powers of attorney for a child the moment he or she reaches the age of 18. Now, the final point I would mention about that is also the financial power of attorney. So there are two types of powers of attorney, healthcare and financial. I just explained healthcare. So a lot of people may say, all right, I've heard you talk about the need for a healthcare power of attorney. I get it now. But my 18-year-old has no money. Why on earth would he or she need a financial power of attorney? And my answer to that is simple. There's two types of powers of attorney, healthcare, financial. Healthcare deals with healthcare. Financial deals with everything else. So there are a lot of things that have nothing to do with the amount of money you have that that are benefited by having a financial power of attorney. For instance, the ability to receive mail, the ability to communicate with a high school or a college saying, hey, this person's no longer going to be enrolled. How do we get our deposit back? Things like that. That cannot be accomplished without a financial power of attorney. So again, basic entry-level estate plan for anyone who reaches the age of 18. Healthcare power of attorney, financial power of attorney. The final point I want to talk about with powers of attorney is how it relates to spouses, because this is yet another area where people tend to make assumptions and they assume incorrectly. So the proposition is, if a spouse ends up in that position, if I'm driving home on Highway 33, you mentioned going on 33, that's probably the way I'm going to head home majority of the time, right? If I'm heading home on 33 and most of 33 is 55 mile an hour divided highway, at least between here and Saukville. Sure, they slow down in some pockets, Horicon, West Bend, things like that, but it's predominantly 55 mile an hour divided highway. Someone crosses the double yellow line, hits me head on, I'm taken to the hospital, I'm in a coma. My wife, even though she's my wife, not only can't make medical decisions for me, she can't even receive information regarding my prognosis unless I have a healthcare power of attorney authorizing her to receive that information and make those decisions. Again, poll the same 100 people at Walmart. I think the majority of them would assume incorrectly, well, it's a spouse. Of course the spouse can make those decisions. HIPAA does not have an exemption for spouses. In fact, what I'd argue is this, and again, this is not in a statute anywhere, this is more practical, okay? About 52% of marriages end in divorce. There are a lot of married couples out there right now who wouldn't want their spouse to be the one making those decisions or even get information about that. There are people on the brink of divorce. There's people who are together only for the kids or for religious reasons, any number of things. So a hospital cannot assume that that person who's married, who enters the hospital in a coma, would want their spouse to receive that information. If they want that to be the case, very easy. Create an estate plan that makes it that case.
In your experience, if somebody doesn't want their spouse making the power of attorney, who might they have? Would it be a parent? Would it be a friend? Or what have you seen in the past?
Most common is an adult child.
Okay.
If they have adult children, that's the most common. But it could be anybody. It could be a friend. And there could be any number of what I would call positive reasons. Or at least non-negative reasons. Sure. For example, if one spouse is diminished in capacity or if one spouse has mobility issues, they may say, okay, if I'm the healthier spouse and I'm out and about and something happens to me, well, my spouse who's housebound may not be the best choice to make those decisions. So that's at least a non-negative reason. I mean, it's unfortunate they're in that situation, but it's not like they don't like their spouse, they don't trust their spouse, whatever the case is. The other one is if there is somebody in the medical or the financial field. I mean, an example would be, like I said, I'm a first-generation lawyer. I'm going to be able to deal with banks and financial companies a lot better than either of my parents would be able to do, so they made me the primary agent, right? I mean, those are just examples of times when you'd pick somebody else, but usually that's what it is. It's an adult child is typically the person you pick if you're not going to pick your spouse.
We're talking with Rob Melick from Melick Law, 920-885-4446 if you have any questions. If you want to send a text, and Corey will pass them along, 920-887-9595. Now, powers of attorney, do you have you slot them? Do you have like does it go down a list, and is it like a draft order, like you cross somebody off, or how exactly does that work if you want to have multiple people, and who makes the decisions, and if you're one, somebody else is two, somebody else is three, or down to 5 or whatever you have? No,
I'm glad you mentioned that, because that is something that I encourage my clients to think about, because let's say you pick your spouses, right? Again, most married people will pick their spouse as primary. Well, my proposition is a very simple one there. If you take any given married couple, there are only 3 possibilities as far as order of death and dying. Husband dies first, wife dies first, they both die together. There's no fourth option there. I think we'd all agree in that hypothetical, statistically speaking, the least likelihood by far is both spouses passing away together. It could happen. Of course, there could be a common accident, but more than likely what's going to happen is spouse 1 is going to pass away, A period of time is going to elapse, and then, of course, spouse 2 will pass away. Well, between the time spouse 1 passes away and spouse 2 passes away, that's the period of time as an estate planning attorney I'm the most concerned with. As if spouse 2 keeps living, and at some point he or she loses capacity, of course, spouse 1 cannot be the one making those decisions because spouse 1 is deceased. So you're right. That's where we should have an order. And the one thing that I do recommend, as opposed to having joint agents, is exactly what you described. I think you used the phrase draft order. Whatever the case is. Two sports guys talking draft order makes a lot of sense. I think that's a fair analogy. Just an order of agents. So it's not as though if I have 2 children, but let's say I have 5 children. I'm not making a group of 5. I'm going to assign child 4, child 3, child 1, child 5. Based upon that. Now, what I always tell my clients is this. A lot of times my clients will say, well, how do I pick those people? I love my children equally. How do I do it? I look at it as a job interview. Okay, so for any job, I'm sure most people in this audience have applied for a job, have been interviewed for a job at some point in their life. Maybe some of you have been the interviewer. Okay, I can tell you, having been both, the interviewee and the interviewer, I have never found a perfect candidate. I have 3 outstanding paralegals. They're great candidates, but they're not perfect because no human being is perfect, okay? The idea is that every candidate for any position brings a set of skills, and it's up to the employer to decide, based upon the needs of the position, based upon the qualifications of the people who are applying, who is the best candidate for the job. And you're willing to accept trade-offs in certain areas. So when it comes to financial power of attorney, the example I give is this. If you view them all equally, consider location. All things being equal, somebody who's local is going to be able to do a better job than someone who's in California. Now, if the one in California is a financial guru or is a nurse or nurse or a doctor in the medical field, well, certainly that may overcome the fact that the person here in Wisconsin has no financial or medical knowledge or training. So it's a job interview, but have them listed there. And again, I encourage my clients' agents, the kids typically, to confer, especially if it's a medical decision. Hey, are we going to, everyone uses the phrase pull the plug. I don't know, a little morbid of a phrase for me, but end of life decisions, right? What do we want to do? Let's weigh the pros and cons. What is mom or dad's quality of life going to be if we choose option A or option B? Fine. Have a group discussion, but at the end of the day, the person you pick as the primary is the one who's ultimately making the decision.
Sure. And that can even call, obviously, if it's in just say a family with multiple adult children.
Yeah.
Sometimes I know everybody, the adult children, if you don't have one, have different opinions on
Right.
what should happen at different times.
Sure.
And the document pretty much would give legally person number 1 in the draft order, as we say, the final say.
Yep.
Even though everybody else might think number 3 or number 2 might be like, no, I really think we need to go this route.
Right. Well, the analogy I use for that is the game Family Feud. When you're trying to steal the question away, the other 4 members shout out answers, and at the end of the day, it's up to the team captain to take one of the 4, go rogue, and pick his or her own example. The problem with that is, what's the alternative? If you give them equal say, how do you resolve that deadlock, right? If you say, okay, I'm going to pick my 2 sons as agents, and son A says pull the plug, and son B says keep it in as long as possible, if they have joint authority, how do you resolve that deadlock? So a lot of times my clients will ask me that question, and I always start with the answer of, look, this is your estate plan. Mm-hmm. You are my boss. You tell me how you want it to go. But I can tell you that I wouldn't be doing my job as an estate planning attorney if I didn't explain to you the pros and cons of having joint agents versus individual successor agents, the draft order, if you will.
Okay, we have a question that came on the text line. It says, can a married woman do an estate plan on their own? You know what I'm saying? I think the question is, like, if you have a spouse, you go and do it completely on your own without your spouse?
That's a fair question. I would tell you that there are marital property laws in place. You have to abide by the Wisconsin marital property laws. But yeah, I've done estate plans for individuals before. I guess my first question would be, without getting too personal, why would you want to do it without your spouse, right? There's a lot of issues that come with that, but you are not required to list your spouse, as I mentioned before. So it just depends on how you have that there. So long as you are willing to avail yourself to Wisconsin marital property laws, or have a document where you've already rescinded those, like a pre or a post-nuptial agreement. But other than that, yeah, it can be done.
Yeah, so it has been done in the past.
Sure it has.
Have they ever been done without the other spouse knowing that you've been doing your plan? Most of the time they're going to know.
Yeah, and that's a little tricky. Again, I'm not a fan of keeping information from somebody there. And like I said, Wisconsin marital property law kind of dictates that in terms of who gets what, how, the presumption of joint ownership, things like that. Because again, not to pick on the person who sent that text, but my question would be, how are you owning assets presently, right? If you own a home, is that in both spouses' names or one spouse's name? Well, we We can't change it without the other person's authority there. So there's any number of issues that would come into play. But my first question would be, why would you want to do it without your spouse? Now, occasionally you have situations where one spouse wants to do the estate plan, the other one has no interest in it. Okay, well, what I would suggest then is have a base estate plan for now. But if you happen to be the surviving spouse of the two, well, then at that point in time, doesn't matter what the deceased spouse says. You can always update the documents accordingly.
Rob Melick from Melick Law, 920-885-4446. If you have a question, or you can send a text, as that person did, 920-887-9595. If somebody wants to get in contact with you outside the show, again, Rob, how do they get in contact with you?
Yeah, so best way to get a hold of me is always by telephone. My office phone number for all 4 of my office locations is 262-347-3444. Again, 262-347-3444. The majority of the listening and viewing audience, my Beaver Dam office would probably be the most proximate. I work out of Sandy and Matt Heyer's office in Beaver Dam, but I do also have offices in Richfield, Port Washington, and West Bend. I always offer free initial consultations too. So anybody who's listening here, you would get a free initial consultation, go over existing documents if you have them, discuss some other options if you're starting from scratch. Furthermore, I do offer a 20% discount to WBEV listeners and Daily Dodge viewers. So if you heard about my program through either of those venues, let me know and we'll apply a 20% discount off your services there.
Since we've been talking about estate planning here, if somebody has been listening and you mentioned, like a lot of people have, just kicking the can down the road, I'll do it tomorrow's. I'll do it tomorrow's, and I'll do it tomorrow's, and then it's too late. Typically, how does that work? You mentioned the initial. What happens in the initial consultation, and how long does it take to get one of those a properly done estate plan in place?
Yeah, so the initial consultation will take as long as you want. I don't put my clients on a timer or prospective clients on a timer. I'll say the average initial consult takes about a half an hour. We just discuss some options, walk through existing documents, come up with a plan. If they want to proceed at that time, I do an intake interview. Like I said, most of my initial meetings take about 30 minutes, give or take. After that point, I have the information I need to draft the documents. Usually takes my office about a week and a half to draft them. We can forward drafts to the clients to review if they'd like, or we can go over them thoroughly at the signing. Final step of the equation is a signing. We have to do it in front of myself as a notary and a witness, but we have that signing. Signing typically takes also about a half hour to 40 minutes, depending on how many questions you have. Documents go into effect that day. Okay. So again, somebody calling now, today, you can easily get it done by the first week of November at that point.
So it's something you have been waiting and you're thinking, like you said, you never know whether you're 18, whether you're 25, or you're 50, or you're 75, you don't have one. It can be done in a relatively timely manner. It's not going to be like a 1 year.
Oh goodness, no. I pride myself on quick turnaround. Like I said, I have 3 outstanding paralegals who assist me in drafting. But again, as the attorney, I'm involved every step of the way. I do every initial consultation. I do every signing. I'm involved every step of the way there. So yes, one of my paralegals may be drafting the documents, but I thoroughly review them before they go to the clients, and I'm always the one answering any questions at that point.
We haven't talked obviously about trust and wills. Or if somebody wants to like get the full boat, they want to do a estate planning, a trust, a will. Is that a longer time frame? Is that pretty much the same thing where it can get done relatively in a reasonable amount of time if they've been kind of kicking the can down the road?
It's the same time. It really is. I mean, I ask a few more questions, but it wouldn't take any longer at that point in time. The other thing is I do have clients who are in exigent circumstances, and we can triage the situation. I mean, triage using a medical term. The idea is if you have 5 people in an emergency room and one of them comes in hemorrhaging after a gunshot wound, you're going to put him to the front of the line, right? Kind of the same thing in my practice. If somebody's coming in, look, I have a stage 4 cancer diagnosis. Can we get this done sooner rather than later? I will put that person to the front of the line. If somebody is in a position where they may lose capacity, but they still have it now, again, same thing, because that's the other issue. It's not merely enough to be alive. You got to have capacity, because if you don't have capacity, we can't execute estate planning documents. So that's something that I always test for as well.
You have estate planning. What about, I guess I'll ask you this first. So once you have the document, where does it live? I mean, does it live in a lockbox in your house, in the safe? Do you put it in a file? What do you do to make sure it's there and where people are aware of where it is at?
Yeah, that's a really good question. So what I always do for my clients is this. I always give my clients the originals and a copy set. If they want more copies, I'm happy to make those copies at no charge. And then I also keep a copy in my cloud-based system. just in case. And people, I get that call about twice a year. People lose their estate planning documents, have no idea where they are. We have a copy of everything. So what I always tell my clients is this, is that when it comes to the originals, put those in the most secure area that you have. If you have a safety deposit box, put in a safety deposit box. If you have a safe in the home, put in the safe in the home. If you don't have any of that and you don't want to go out and buy it, that's fine. Just make sure that it's accessible to your agents. So again, typical situation, you have a couple, they have adult children. What I always do is I tell them, look, put it somewhere in the house where everyone knows it is, even if it's as simple as the third drawer of the armoire in our bedroom. Okay. That way the kids, if there's an emergency, can get it and access it quickly. If you want to make extra copies for your kids, you certainly can. Not a requirement, but at a bare minimum, they should either A, know where the documents are. That's the one I recommend. Or even the barest of bare minimums is give them my contact information. So if there is an emergency, I can call and pick up. The problem is, depending on when this emergency falls, let's say it's a situation where it's around Christmas this year, right? I mean, our office is closed on the weekends typically. Christmas is on a Wednesday this year. I don't know what my paralegals are going to choose in terms of which days they're off or whatnot, but there's a possibility 5 days could go beyond when they have access to the documents and when they don't. So I don't like relying on, I don't want my clients to rely upon just saying, oh, we'll call the lawyer to get the documents. So we do have a copy as a backup emergency type thing, but making sure that your children or other loved ones or other agents know where to find those documents in an emergency is certainly what I recommend.
Yeah, it's one of those things where, again, you don't know, as soon as it's done, let them know where it's at, because you never know. Like I said, walking out of work today, you could end up having something happen, and people are trying to search. How big of an issue does that become then? If people didn't, if somebody knew that Gladys had a will, had an estate plan, had a trust, but then something happens and she's like, oh, we know she's got one, but we don't know who did it. We don't know where it's at. So it's basically like you don't have it.
Yeah.
Isn't that the case?
Happens all the time. And what I always tell my clients simply is if you can't find it, it doesn't exist. I mean, it's really that simple. So one of the ways we work around that is we make sure we retain a copy of it. Now, admittedly, I will say this. I've been privileged in the fact that I grew up when I grew up. Attorneys a generation older than me didn't have the ability to have cloud-based storage systems and things like that. They have basements full of documents, right? And if I grew up in that era, I don't know if I'd keep all my clients' documents either, because to be clear, there is no ethical obligation for the attorney to keep documents. Mm-hmm. A lot of people think there is, but there is not. That is not a legal requirement at all. I do it as a courtesy to my clients for exactly the situation you described, but I would say I'd say at least once every other month, I will get a call from somebody asking, hey, did you do Gladys's estate plan? And I can tell them, no, I didn't. That I can tell them. So if I did, then I have to go through some other channels because of attorney-client privilege, but I can certainly tell them I did not do it if I did not, in fact, do it. But again, going back to the accessibility of it, the other two things that I'll say here, and I'm not trying to be funny with this one, but it's 100% true. I get a couple calls a year saying, hey, what is the combination of my parents' safe, or do you have the keys? I have never once in my practice taken a combination of a client's safe or the keys. So if you're going to put it in a safe, make sure your kids or other loved ones know how to get into the safe, okay? That's a practical piece of advice, right? The secondly deals with safety deposit boxes, because I have a lot of clients who have safety deposit boxes, and what I will tell you, and again, this is one of those things that escapes a lot of people at first blush, but if you think about it, it kind of makes sense. A safety deposit box is really a lease with you and the bank for a very, very tiny place of space, right? And the idea is that it's contractual. Just like if I rent an apartment or rent an office building, it's contractual. There's certain things I can and can't do. Payment, what I can do, so on and so forth. Safety deposit box is the same way. So I always encourage my clients to talk to their banks to say, look, I want my kids to be able to access this box when I die. What do I need to do to make sure that happens? Because the problem is you could have 10 different banks with 10 different responses. Some of them will require them to have keys now. Some of them will just require a death certificate. Some of them require estate planning documents that nominate these people. There's any number of variables, but it's very important that you talk to your bank, even if you don't have an estate plan, even if you just have other valuables in there. How do they access? Because I run into that quite a bit. That the clients, while they were alive, did not cross all their T's and dot all their I's in terms of how to make sure their loved ones can access that safety deposit box upon their demise.
Sure. So you made somebody a power of attorney, but the document that tells them their power of attorney is behind a door that they can't access without the document.
Right. And the other thing too with that is, just to be clear, power of attorney terminates at death. Yeah. So that wouldn't even apply. It would be the will that would nominate, or the trust that would nominate them as the executor, the trustee. And you're right. If it's behind a set of rules that you can't comply with, that's a problem. So again, those of you who have safety deposit boxes out there, whether you're concerned about estate planning or not at this point in time, make sure that you talk to your bank and find out what the requirements are. Because like I said, 10 different banks will have 10 different responses. There's nothing I can do as a lawyer to supersede what's in your lease for that safety deposit box. I have to comply with what the terms of that lease say.
Talking with Rob Melick from Melick Law here on 95.3 WBEV and also on Daily Dodge TV. We appreciate you joining us here today. Again, we still have time for a question. If you have one, 920-885-4446. Or if you want to send a text, 920-887-9595. And as you mentioned, it's just the great unknown for a lot of people. That's why I appreciate having you on, because people are like, I don't want to do it because I'm not quite sure where to start. Well, you can be the starting point, right?
Exactly. And I do take those calls. So even if you're just unsure, give my office a call. Again, my practice model is pretty simple. I don't charge for advice, because advice in a vacuum does nothing. You have to put the advice into a set of legally binding estate planning documents in order for that advice to have an effect. So if there's questions, call me. Happy to answer those questions at no charge to you. But again, hopefully the answers to those questions encourage you to create a plan, because that's the only way to make sure that the advice is actually implemented.
When you were going to law school, did you think you were going to go this direction, or how did you find yourself helping people plan their future with wills, trusts, estate plannings, and things?
Yeah, I had no idea. It was one of those things where I was an economics major as an undergrad. Kind of knew I wanted to go to law school. I always kind of wanted to be a lawyer. So in that sense, I kind of had an idea. But really what it was my first job out of law school, I was a commercial litigator. I was just arguing cases, things like that. Actually, no, better said, I was preparing the more senior attorney on how to argue cases. I was reading a lot of cases, drafting a lot of documents, things like that. Paid the bills, that's for sure. Helped with the student loan debt, but not something I wanted to do long term. So I ended up leaving that job, going to another firm. That was more of a general practice. And when I was at that general practice firm, I worked a lot with the attorney that did estate planning. And one of the things he said, and this stuck with me, he said, if you want to have a low stress, highly rewarding area of practice, pick estate planning, because estate planning is one of the only areas of the law that, one, has no court deadlines and no opposing counsel. Now, court deadlines, there are some court deadlines, but they're very flexible when it comes to probate court. But as far as no opposing counsel, it's a good thing. He also said it's also the one area of the law where everybody needs your services. Not everybody is going to go through a divorce. Not everybody is going to get accused of committing a crime. Not everybody is going to have a personal injury action, but 100% of people are going to pass away at some point in time. And 100% of the people, whether they know it or not, whether they do it proactively or retroactively, are going to need the services of an estate planning attorney. So that was great legal advice, and I followed it, and I'm very happy that I did 16 years later.
We have another question off the text line, Rob. What are some of the common questions that you'll be asked if they come in to see you for an initial consultation?
Yeah, so I guess the first question would be explaining to them the differences between will and trust-based planning. And I'll give the Cliff Notes version now, and if we have time, I'll expand upon it later. Because a lot of people, going back to a misconception, probably the biggest and maybe most dangerous misconception is that people think wills are enough. Most people think, well, if I have a will, I'm done. That's all I need to do. To be clear, wills can avoid probate, but only trusts are guaranteed to avoid probate. And that's something I emphasize with a lot of my clients. What is probate? Probate's the process where a court oversees the administration of an estate. Reasons we want to avoid probate: it's expensive. Average cost of probate is about $8,000 to $12,000. It's time consuming. Average length of probate is 12 to 18 months, and it's all public record. So one of the first questions I will ask is a very simple one: do you own your home? Because if you own your home, there's a very high probability you have more than $50,000 worth of worth of equity in the home, which would cause the estate to go through probate. That's the threshold. In other words, if you have a will and you have more than $50,000 worth of probate assets, the estate goes to probate. And that surprises a lot of people. So that's the path I kind of lead people down. The other thing is just determining the order of which you want your agents. We talked about it before, the draft order that you mentioned. How do we want assets divided? Do we want it all divided evenly among children? Do we want to include charities? What about grandchildren? Do we want grandchildren directly included, or do we only want grandchildren to receive money upon the demise of their parent? How old do we want the grandchildren to be? I can't turn money over to minors, but I may not necessarily, or my hypothetical clients may not necessarily want to turn money over to a child or a young adult the moment they turn 18. I want them to mature a little bit, become a little more worldly, a little more responsible. So those are the types of questions I ask. Like I said, my average intake interview takes about 10 minutes. So it's not a long drag. I think a lot of people think, I need to bring bank statements. I need to bring every single asset that I have, and you really don't. Because candidly, I don't need that information. What I do when it comes to funding an asset is, first of all, what type of estate plan you have. Because broadly speaking, there's will-based, trust-based, as we discussed before. But depending on which of those options you pick, I can give you guidance on asset type as opposed to individual assets. So for example, The advice that I give you, if you have a checking account that has $10 in it versus a checking account that has $100,000 in it, is exactly the same. I don't need to give differentiated advice there. The consequences of not having beneficiaries are very different. One goes to probate, one doesn't. But at the same time, the advice as far as beneficiaries is exactly the same. So as far as that initial consult, I don't really need a lot of information from my clients or prospective clients. I just need you to have some sort of idea as to whom you want to be in charge, and then addresses and phone numbers of those folks. I mean, the example I always give is this. Doing what I do for a living, I know how to get to my sister's home. I know I've been there, a dozen times or so. She just moved a couple years ago. However, I couldn't tell you what the address is. I have no idea. But I need to know that address if I'm going to create a sale. And so however people keep it, whether it's in a phone book, address book, bring that to the first meeting. That way we don't have to schedule something else.
Excellent. Again, it's one of those things we've been waiting on. You mentioned no cost for the consultations, but it's an important thing where it calls you. If you kick the can too far, you might be caught in a situation where you don't have anything. And get it done. You'll answer the questions to make it happen. Yeah.
Well, what I will tell you is this, and I think I mentioned this on the last show, but I may not have. Currently, I have a slogan pending at the U.S. Patent and Trademark Office to describe my practice.
Okay.
Before you die, call this guy. Mm-hmm. It's kind of rhyming 6 words, but it kind of encapsulates my practice in a nutshell. Before you pass away, you got to give me a call to make sure that everything goes the way you want it to go. So we unveiled it at our Washington County Fair, and it was about a 98% approval rate. Unfortunately, as I always mention, my wife was in the 2% who didn't like it, but we talked her into it, and we got it before the Patent and Trademark Office. So
somebody had asked about the legality of another text about the legality of going online and printing off forms and how the legality of that and if they can really hold up in a court situation.
Yeah, typically not, but it's a function of the form itself. I mean, it's one of those things where you kind of know it when you see it. There's certain formalities that a document has to have. To be clear, a document does not have to be drafted by a local lawyer to be enforceable. But if it does not have the requisite requirements, it's unenforceable. So the analogy I draw is this, okay? I'm going to pick an area that maybe some people in the audience know a lot about. I know next to nothing about, but it's a good analogy. Auto repair, all right? The example would be this, okay? What percentage of people have the knowledge, the physical dexterity to be able to change out their own transmission? I'd argue a very, very small percentage of people. Can it be done? Sure, it can be done. I can go on YouTube and watch a whole bunch of videos on how to replace a transmission. Am I going to do it? Am I going to do it correctly? Probably not. I think the same can be said about estate planning documents and forms you find online. Maybe they'll be done correctly, but more than likely they won't be. And if they do fail, what's your recourse? If they fail here, I'm accountable. The agents, the kids can call me and say, what happened there? You get it off online, who knows what you're getting?
Yeah, well, Rob, if somebody wants to get it done correctly, Melick Law is the place, right? To explain again how they can get in contact with you and begin the process of, setting up their future and making sure everything's in place.
Absolutely. Best way to get a hold of me is by phone, 262-347-3444. Again, 262-347-3444. Call that number 24/7. If you prefer to text that number, you certainly can. Office locations in Beaver Dam, Richfield, West Bend, Port Washington. Always a free initial consultation and 20% off legal fees if you heard about me on WBEV or through dailydodge.com.
Rob, I appreciate you always coming in, and I learned some stuff today. I think we do every single time you come on, and one of those things, as you mentioned, people sometimes just a little unsure about it. You kind of make us feel more comfortable in knowing what needs to be done to make sure our family and everything goes the way we want it.
I appreciate that. Thanks for having me.
Thank you very much. This has been the Melick Law Show on 95.3 WBEV and also Daily Dodge TV. Thank you so much for joining us today.